Good afternoon, everyone. It is Wednesday, Thanksgiving Eve. I'm a little early. I wasn't supposed to start until 12:15, but I was ready a little earlier, so I hope you don't mind. Today we're just going to go over some of the Karen Reed updates from this week. I hope everyone's doing fine. I hope everyone is ready for Thanksgiving. I work tomorrow night, so there's that. So I won't be partaking in very many festivities, but I hope you all get the chance to. Um, so apparently today, the Karen Reed civil case has been moved to federal court. And I'm not sure as to why. There's no papers in downloaded yet, but there is an article that I'll read to you in regards to that. And then I'm also going to go over the defendants, the McAlberts, and those people, the House defendants, I should say. I'm going to go over their opposition to Karen Reed's filing. And then we're also going to go over Michael Proctor's, the filings from Karen Reed in regards to Michael Proctor. So, yeah, it's going to be kind of a heavy day of reading. I think they're like an average of 8 to 9 pages, maybe a little longer. So, bear with me. And let's get going, shall we? Okay, so let me see. I'm first gonna go over the article about the Karen Reed. Sorry, I thought I had this up, but apparently, of course, I didn't. So, how'd you like Turtle Boy's live last night? Pretty wild, huh? Crazy. I think his Spaces live was better. I mean, that was pretty impressive. He got a lot of feedback from that, and I think he was right, to be honest with you. I mean, I think they're better off together. I don't know what's really going on behind the scenes, but he definitely put his reputation, his basically his life on the line and on hold for the last 2 years. But definitely, he went without his kids for 60 days, and they wanted to go 90 days, but they couldn't. They tried, but they couldn't. So I'm not sure what is going on with Karen. I wish for the best. I'm glad she's free, and I hope she can put this all behind her at some point. But I think Turtle Boy is the wrong person to be angry at and to be taking stuff out on. That's just my personal opinion. And I have nothing against Karen Reed. I'm not taking a side either way. That look at the big picture. You guys may be totally different as far as personalities go, and he may not be your cup of tea. or somebody that you would be friends with outside of this situation. But this is a unique situation, and you have to just accept him as he is. He's accepting you as you are. He knows that you guys have really nothing in common other than your trial, and he's okay with that. He doesn't feel like you guys have to be friends, but you should be civil to each other. That's just, anyway, that's my opinion, and I'm not saying anything more. How's that? So here we go. I probably said too much as it is. I hate that when they want to show you all these stupid ads. I don't want to open an account, but it won't show me the title of the article because I don't want to open an account. Whatever. So, is it showing you guys? Okay. We'll make it bigger. How's that? Alrighty. So, Karen Reed's civil suit against several witnesses who testified against her in the John O'Keefe murder trial will be moved from Bristol County Superior Court to the United States District Court for the District of Massachusetts. In a court filing on Tuesday, Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins claimed Reed's civil case is quote, a vengeful abuse of the judicial process, end quote, and that it's an, quote, ongoing and malicious attempt to evade responsibility for the death of John O'Keefe, end quote. Well, they just get right into it, don't they? The Alberts, McCabes, and Higgins asked to move court venues and pointed specifically to Reed's claim that her Fourth Amendment rights were violated during the investigation into O'Keefe's death. But they didn't have anything to do with the investigation, so why are they even addressing that part of it? I don't think that part of it has anything to do with them. The Fourth Amendment protects people against unreasonable searches and seizures. Today's filing says that part of her complaint is, quote, exclusively and expressly based upon the federal statute, raises substantial federal issues central to establishing claims for relief, end quote. According to the court's website, the case was transferred to the U.S. District Court. O'Keefe was found dead during a snowstorm on January 29, 2022. Earlier this month, Reed filed an explosive lawsuit alleging that others were responsible for his death and that investigators failed to pursue those leads. You know, they make it sound like it's a surprise that she is doing this. I mean, they had to see it coming, right? And why haven't they filed a defamation lawsuit if they really truly believe that they have grounds for it? Because they don't. Otherwise, they would have filed a defamation lawsuit against Turtle Boy a long time ago, right? And he's been daring them to, and they just won't do it because they can't. She was found not guilty of murder this summer after a second high-profile trial in the death of O'Keefe, a Boston police officer. Reed was found guilty of drunk driving. Yeah, that was probably the most expensive drunk driving case Norfolk County has ever seen. Massachusetts has ever seen. I mean, they had 2 trials totaling millions of dollars for what? A convicted DUI? Wow. That's embarrassing. And the taxpayers should be pissed. I mean, what in the fuck are we doing here, right? I'm not saying, California's probably not much better, but we just haven't had a case like this to bring it to the public. Now, quote, now after being acquitted of all charges relating to Mr. O'Keefe's death, Miss Reed brings this action to recover for and address the actions of those actually involved in Mr. O'Keefe's death and the law enforcement officers who abjectly failed to ensure that justice was sought and served, end quote, her lawsuit states. It names as defendants former trooper Michael Proctor, Sergeant Yuri Buchanan. Did anybody see how Yuri Buchanan was promoting the McAlbert's fundraising for their lawyers' fees? Yeah, he can't do that. That's a violation of something, I'm sure. That's a total conflict of interest. I mean, Michael Proctor just went through this. So why would he put his ass on the line like that? What an idiot. He's not the sharpest tool in the shed or what, you know. I mean, what a freaking idiot. Got a size 3 head, basically. Sergeant Yuri Buchanan, Lieutenant Brian Tolley, Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins. We sure haven't heard much from Brian Higgins, though, have we? 5 of those witnesses claimed they planned to sue Reed and Turtle Boy blogger Aidan Carney for defamation, though no lawsuit has been filed. Because they're not going to. Let's keep it real. Let's be, you know, they're not going to. Otherwise, they would have by now. So, there we have that. Now, we're going to go over the McAlbert's opposition. I think. I know I just downloaded this, so where it would be, I don't know, but we will find it. I hate that. I'm not good enough at computers to know where stuff goes when you download it. Does it mean, I always thought that it goes wherever you, just to the download folder, but apparently I'm wrong because I'm not seeing it. I thought it would just automatically go to the download folder, doesn't it? Oh my God. Cheese and rice. Just 1 second, I'm sorry. I mean, I guess I can just read it directly off the site, but that kind of defeats the whole purpose of downloading it, right? I don't think this is it. Nope, that's not it. Holy crap. Okay, so then we will do it this way. I'll just read it directly off of Scribed. Maybe. Sorry, guys. I don't know why it didn't download. But we will get it. It's right here. Karen, civil case Found it. Again with the stupid find the... Oh my gosh. I was just in here and now it's going to make me sign in again. Sorry, guys. Oh my gosh. So anyway, does anybody have big plans for Thanksgiving, or is everybody staying home? Do you cook, or does your husband do the cooking? Um, I feel bad because nobody's going to be here to cook for my husband and my son. So I was going to cook for them and just do it tonight. But when I asked my husband about it, he didn't seem too interested. So there's that. So I just said, okay, well, if it's not a big deal to you, it's definitely not a big deal to me. Because I have to work tomorrow night. So not cooking a big meal tonight wouldn't hurt my feelings at all. Okay, come on, come on, come on, come on, come on. Oh, I have to hit get good. So yeah, I do love sweet potatoes though. Homemade sweet potatoes. Ooh, 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 ooh. Those, I love those. But I can still make those tonight. I don't have to make a big old turkey, but I feel bad because my husband loves the big turkey, and my father passed away this year, and he was a big Thanksgiving guy. We so I feel bad that I'm not going to be with my mom, but I believe she'll be at my sister's, so I feel okay about that. But still, it's no bueno when you can't be with your family times like this, you know? Oh my God, how many, I mean, they want to make sure it's me, but oh my gosh. What the hell? I'm sorry. Okay, well, oh my God. Okay. So anyway, yeah, I'm not a big Thanksgiving meal eater. I mean, I eat. Don't get me wrong. Like you couldn't tell that I do, I don't. I mean, like you couldn't tell I eat. But as far as I'm eating enough to make it feel like it's worth my while to cook the meal, not so much. I mean, I cook it, and but like I said, my husband didn't really seem too interested in it to this year. So, but he is going somewhere with his father on Saturday. He's going to take his dad to at a Thanksgiving meal, so at a friend's house. So there's there. It's not like he's being cheated out of a Thanksgiving dinner. He will still get his Thanksgiving dinner, and he will be fine. If he really, he's not shy. If he really wanted me to um, cook him a Thanksgiving meal tonight, he would have let me know. Trust me. So there's, and it's not too late. I still could. It would be a late dinner, obviously, but there's nothing wrong with eating late at night, right? I mean, I do it all the time because I work nights, so it's no big deal to me. Okay, we're gonna, while that's brewing up, we're gonna go to Karen Reed's filing for Michael Proctor. Let me see. Let me get back to you. From what she wants Michael Proctor to produce to the court. Um, okay. So this was filed on the 25th, I believe. Yes. Motion to compel Michael Proctor to produce documents pursuant to subpoenas. Defendant Karen Reed respectfully requests that the court compel former Massachusetts State Police Trooper Michael Proctor, disgracefully former Massachusetts State Trooper Michael Proctor, to produce documents due as long as 3 months ago. Reed served a subpoena, the first subpoena, on Proctor in hand in July of 2025. Reed also served a second subpoena seeking a discrete set of additional documents in October 2025. Proctor acknowledged receiving both subpoenas and requested repeated extensions to respond. However, to date, Proctor has failed to meet all new agreed to deadlines and has not substantively responded to either subpoena or produced any documents. The court should compel him to do so. In support of this motion, Reed relies on the memorandum of law submitted herewith. One thing I've noticed watching the Reed case and the Turtle Boy case and all the subsequent cases is Massachusetts doesn't really enforce deadlines for their Commonwealth, for the prosecutors, and for the officers that might be involved in cases and whatnot. They do for the defense, of course, but they don't for like Proctor's getting away with not. I mean, isn't that why Lally was on the stand for the Miles King hearing, because he didn't make Proctor give him the search warrants that they'd asked for months and months and months and months, now years ago, I think. I just don't get it. Wherefore, Reed respectfully requests that the court allow this motion and compel Proctor to produce all documents and information responsive to the subpoenas within 10 days of the court's order. Respectfully submitted, Karen Reed, by her attorneys. Okay, that was on November 7th, 2025. Certification of service, November 7th, 2025. Commonwealth of Massachusetts Superior Court Department. Defendant, okay, is this the same thing? Yes, so this is the same thing. So, Certificate of service. Is this the same thing? Yes. What's going on? Okay, so it's in there like 15 million trillion times. Okay, so I did... Okay, sorry. So we're starting off like a bat out of hell, aren't we? Jesus Christ. I mean, can I ever do any of this right? I don't... Oh my gosh. I whenever I think it's going to go smoothly, it doesn't, but that's okay. As long as you guys are patient, I will produce, I promise. I hope. No, I have to have a little bit of faith in myself, right? My God. The whole I'm not a robot crap just irritates the hell out of me. Okay, she's in Bristol, right? Okay. But now I'm hungry. Talking about all that is making me hungry now. What's going on here? Case closed. Administrative civil actions. Huh. That's weird. They still haven't put notice of removal to the United States District. Oh, they did add it now. Okay, well, we'll go over that then. Did my... Let me make sure that my earphones are, because they just made a weird noise. So they're connected. Okay, sorry. I don't know what it matters, but anyway. So they did add it since I've been on with you guys. So let's see what it says, shall we? Because it says that the one in the district court or the superior court is, or the state court is now closed. So there's that. Okay. So, Commonwealth of Massachusetts, Superior Court Department, Bristol County, Karen Reed plaintiff. No, it's because my earphones are going dead. All right, well, there's that. Notice of filing notice of removal of action to federal court. November 25th, 2025. Please take notice that Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins have, on this date, filed a notice of removal in the United States District Court for the District of Massachusetts pursuant to, and it gives the case law. A copy of the notice of removal and all accompanying documents is attached hereto as Exhibit A. This is a 66-page document, so we may have to do this in two sittings. Wow. Wonder why it's so much. Certificate of service. Exhibit. So this is the civil cover sheet. Defendant, listing all of the defendants. Listing Karen as the plaintiff in Bristol's, and it's This is their county of residence is Norfolk. Basis of jurisdiction, federal. Question, whatever that means. I don't know what any of this means. This is where Melanie Little saves me. Removed from state court. I wonder who made the decision to do this. Jury demand, yes. So they want a jury trial. Now, who demanded, who can put in a motion for it to be moved to a federal court? Is that the defendants or the plaintiff? United States District Court for the District of Massachusetts. Karen is the plaintiff. Notice of removal. Defendants, Brian Albert. Is this what I just wrote? The United States Court for the District of Massachusetts, yeah. Footnote 1. In filing this notice of removal, removing defendants preserve all defenses and objections, including those pursuant to Federal Rule of Civil Procedure. When a defendant removes an action from a state court in which he has been sued, he consents to nothing and quote-unquote waives nothing. He is exercising a privilege unconditionally conferred by statute. And since the district court to which he must remove it is fixed by law, he has no choice, without which there can be no quote-unquote waiver. Document 1, filed yesterday. Statement of the case. Number 1. On or about November 17, 2025, plaintiff Karen Reed filed the above captioned action in the Superior Court, the state court action. The complaint purports to assert 7 causes of action. Malicious prosecution under the Fourth Amendment, count 1. Count 2, conspiracy to deprive Miss Ring of her Fourth Amendment rights. Count 3, Massachusetts Civil Rights Act. Count 4, common law malicious prosecution. Count 5, intentional infliction of emotional distress. Count 6, and civil conspiracy. Count 7, with counts 3, 4, 5, and 6, and 7 being asserted against, and civil conspiracy, count 7. So the numbers came after the counts. Sorry about that. Being asserted against the removing defendants. A true and correct copy of the complaint, civil action cover sheet, civil tracking order, acceptance of service on defendant Brian Tolley, and acceptance of service on defendants Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins are attached hereto as Exhibit A, footnote 2. No proceedings have occurred or been scheduled in the state court action. Accordingly, Exhibit A constitutes a process, pleadings, and orders that have been served on removing defendants or retrieved from the Superior Court's docket prior to the filing of this notice. Number 2, by way of background, the Superior Court action arises from plaintiff's ongoing and malicious attempt to evade responsibility for the death of John O'Keefe by smearing and defaming witnesses who participated in the prosecution of her. Well, in the second trial, the only person that took the stand was Jennifer McCabe. So so as far as them all being witnesses for the second trial, bullshit. The case is a vengeful abuse of the judicial process, and removing defendants will make arguments in that regard at the appropriate time. Removal. Number 3. Counsel for removing defendants accepted service of process on removing defendants' behalf on November 25, 2025. Therefore, removing defendants are timely filing this notice of removal within the 30-day time period from date of service set forth. 30-day removal period runs from service of summons and complaint. Number 4, all named defendants who have been served consent to and join in this removal in accordance with, and it gives the case law. Defendant Brian Tolley's acceptance of service was docketed in the Superior Court on 2025, and counsel for defendant Tolley has confirmed that he assents to this removal. While no acceptance of service has yet been filed with respect to defendant Sergeant Yuri Buchanan, Sergeant Buchanan's counsel has informed undersigned counsel that he consents to removal. Upon information and belief, defendant Michael Proctor has not yet been served, but his counsel has advised undersigned counsel that defendant Proctor consents to removal as well. A civil action removed pursuant to Section 144(1)(a) requires the consent of all defendants who have been served. Number 5, venue is proper in this court pursuant to 28 U.S.C. because the United States District Court for the District of Massachusetts is the federal district in which the Superior Court is located and where the state court action was originally filed. Number 6, as required by 28 U.S.C., removing defendants will promptly serve written notice of the filing of this notice of removal and the removal of the state court. Action on counsel for plaintiff, as evidenced by the attached certificate of service, and will promptly file the same with the clerk of the Superior Court. Pursuant to 28 U.S.C. and LRD Mass 81.1, within 28 days of the filing of this notice of removal, removing defendant shall file certified copies of all records and proceedings in the Superior Court, as well as a certified copy of the docket and all docket entries. Number 8, the removal of this action terminates all potential proceedings in the Superior Court. Federal jurisdiction exists under 28 U.S.C. Number 9, this is a civil action over which this court has original jurisdiction under 28 U.S.C. and is one that may be removed to this court under the same U.S.C. because, as set forth more fully below, plaintiff's federal civil rights claim against removing defendants, namely count 3, conspiracy to deprive Miss Reed of her Fourth Amendment rights against Proctor, Buchanan, Tully, the Alberts, the McCabe's, and Higgins, is exclusively and expressly based upon the federal statute, and therefore raises substantial federal issues central to establishing plaintiff's claims for relief. Footnote 5. Well, what happened to footnote 3 and 4? Did I miss some? Oh, there's 4. So where's 3? How did I miss it? I have a headache today. So footnote 3 right here. Okay. Removing defendants have not yet filed an answer or otherwise responded to the complaint, but will file such an answer and or response absent an extension within 21 days of service in accordance with the federal R Civil P. As noted, removing defendants accepted service of process on November 25th, 2025. And the footnote 4 is after the removal of this action terminates all potential proceedings in the Superior Court. Removing defendants have good and sufficient defenses to this action and do not waive any defenses, jurisdictional or otherwise, by the filing of this notice. Removing defendants intend no admission of fact, law, or liability by this notice and expressly reserve all defenses and or motions. And then footnote 5 was after. Footnote 5 is after. Is exclusively and expressly based upon the federal statute and therefore raises substantial federal issues central to establishing plaintiff's claims for relief. Footnote 5. Counts 1 and 2 of the complaint assert separate 42 USC claims against defendants Proctor, Buchanan, and Tully. In particular, plaintiff alleges in count 3 of the complaint that the removing defendants violated her federal civil rights by purportedly acting in concert to deprive her of her Fourth Amendment rights under the United States Constitution. Well, la-ti-ta. Excuse me. The complaint invokes 42 USC. Federal question jurisdiction exists. Sorry. Parents, quote, almost by definition, a claim under 1983 arises under federal law and will support federal question jurisdiction so long as it does not clearly appear to be immaterial and made solely for the purpose of obtaining jurisdiction. End quote, Prince. Okay. Providing court has jurisdiction over counts alleging conspiracy to deprive plaintiffs of their constitutional rights under 42 U.S.C. 1983. In addition, this court has jurisdiction over the remaining counts in the complaint by way of supplemental jurisdiction under 28 U.S.C., which provides in relevant part, quote, in any civil action of which the district courts have original jurisdiction, the district court shall have supplemental jurisdiction over all other claims that are so related. That are so related to claims in the action within such original jurisdiction that they form part of the same case or controversy, end quote. Indeed, the First Circuit has explained, quote, state and federal claims are part of the same case or controversy for the purposes of Section 1367A if they derive from a common nucleus of operative fact or are such that they would ordinarily be expected to be tried in one judicial proceeding. Plaintiffs' claims refer to and rest upon the same allegations, incorporating the allegations set forth in the preceding paragraphs. Accordingly, this court may exercise supplemental jurisdiction over the remaining 4 state law and common law claims, counts 4 through 7 in the complaint. Conclusion. Wherefore, defendants Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins respectfully request that the state court action be removed to the United District Court for the District of Massachusetts, and that the court enter such order as may be necessary to accomplish the requested removal. Respectfully submitted, Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins by their attorneys. Yet only one attorney signed it. I don't get that. They have one attorney speaking for them and everything else, but yet they say they all have their own attorneys. Oh, is this all their attorneys? Maybe. I don't know. Okay, so is that Exhibit A? Is this the same thing? That's the complaint that she filed against them. You know, starting out with the 3.5 years and all that. We already read that, so we don't have to read that again. That's her civil filing against all these defendants. Remember, that's where the House defendants came from. That was a long one. Sorry, guys. I'm just going to look for the end of it and see what else there is that we haven't read. This is just an exhibit that they included in their motion. Basically a copy of Karen Reed's filings against them. I didn't realize hers was this long. Wow. Well, I read it 2 or 3 times, but every time I tried to post this stream, there was no audio, so I gave up. I thought it was possessed. So you're right. So I didn't go over this with you because I did have 2 streams posted, and I was notified by a very polite gentleman that brought it to my attention that there was no audio. So I pre-recorded the stream again and reposted it. And again, there was no audio. So I gave up. I was too discouraged, and I almost gave up completely on my channel because I thought I just can't do this. It was just very disheartening because, as you see, this is a very, very long filing, a very long brief filed on Karen Reed's behalf. So it was very disheartening that I went through it twice, 2.5 hours each time. And and both times when I posted it, there was no audio. And so I thought, I'm not doing it a third time. I just can't. I was broken. Anyway, civil action cover sheet against Michael Proctor, Brian Tolley, Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, Brian Higgins. They want a jury. Statement of damages required. Is there a claim under GL? No. Is there a class action under Mass R? No. I don't know what any of this means. So this is where I need Melanie Little. This is civil action cover sheet instructions. Okay. Tracking order. So this is service of process. This is all the dates that they have to be served by, filed by, and heard by. So they're hoping to have a judgment issued by 11/17/2028. Final pretrial they plan on having on 5/8/2028. So about 2 years. Acceptance of service of process. This is the serving of Brian Tolley. And this is Karen acceptance of service. Accept service process upon them. That's their accept. So, yeah. So then it's going to civil. It's going to Superior. Sorry, that was my dog. I think I beat him. Beat her. But so it's going to federal. Wow. What do you think about that? And let's try and find. Oh my God, my dog. The opposition. Now I'm going to try and find their opposition. I still want to see what she wants the court, what she has subpoenaed from Michael Proctor. Because I'm not sure what she subpoenaed from him. I wonder. No, it says documents. It doesn't say anything about phone data. It just says documents. So I'm wondering what it is that she wants from him. I don't know. Okay. Okay. Opposition. Okay. So, I found it. Let's read it, shall we? I don't know what's going on here. Okay, let's try that again, shall we? Share screen. I don't know why it's doing that. I don't want this one. Just 1 second. I don't know what's going on. There we go. Okay, now why is it doing that? That's so weird. I have no technical brilliance at all. So we're going to try this one more time. Share screen. Share. Okay. My scribed has expired, so that's why I was having a hard time finding it. So this is the Superior Court of Plymouth. It's Paul O'Keefe and plaintiffs v. the Hospitality and Karen Reed and all that. Okay. Non-parties: Jennifer McCabe, Matthew McCabe, Nicole Albert, Brian Albert, and Brian Higgins's opposition to Karen Reed's motion to add parties pursuant to Mass R. Civil P21. Non-parties and witnesses in the Commonwealth's prosecution of defendant Karen Reed: Jennifer McCabe, Miss McCabe, Matthew McCabe, Nicole Albert, Brian Albert, and Brian Higgins, collectively the Commonwealth witnesses, gag, having been served by defendant Karen Reed with her motion for leave to add parties pursuant to Mass R. Civil P21, along with a proposed cross-claim pleading proposed cross-claims, hereby write to the court to oppose the motion. That was a lot of nothing. Defendant Reed's proposed cross-claims and related factual allegations against the McCabes, the Alberts, and Mr. Higgins are a vile work of fiction lacking any basis in fact, evidence, or law. Indeed, these outlandish allegations are part of defendant Reed's scheme to defame and wrongfully malign the Commonwealth witnesses, aka House defendants, to evade responsibility for her actions on the morning of January 29, 2022, and for causing the death of Officer John O'Keefe. The Commonwealth witnesses vigorously, dispute defendant Reed's allegations and will defend against these false claims. The Commonwealth witnesses' defense will include motions to dismiss, potential removal of these claims to federal court, as well as counterclaims against defendant Reed and third-party Aiden Carney, aka Turtle Boy, for defamation and other torts that they have committed individually and in concert. That is yet to be proven. The Commonwealth witnesses, however, should not be forced to litigate these false allegations and their own defamation claims in this pending lawsuit brought by the family of Officer O'Keefe against defendant Reed and two other defendants for their role in causing the death of Officer John O'Keefe on January 29, 2022. The wrongful death action. Bringing defendant Reed's proposed cross-claims into this action, along with the Commonwealth witnesses' defamation and other tort claims, is procedurally improper at this stage and will substantially increase the claims, parties, factual disputes, and legal questions in this case without any evident economies of scale. Moreover, plaintiff's wrongful death action is currently past the motion to dismiss phase, with discovery having commenced. If defendant Reed is permitted to file these claims relating to her criminal prosecution in this case, the motion practice on her pleadings will likely take months. Then, if defendant Reed's proposed cross-claims survive dismissal, the Commonwealth witnesses will file their own counterclaims against defendant Reed and Mr. Carney in this action. Those counterclaims could, again, trigger months of motion practice. As such, the current discovery schedule could almost be over before the pleadings are closed on defendant Reed's proposed expansion of this case. Accordingly, defendant Reed's motion should be denied, and she should be directed to file her proposed pleading, if at all, in a separate action. In that separate action, depending on what claims survive dismissal, it may be appropriate for the parties to consolidate the cases pursuant to Rule 42 of the Massachusetts Rules of Civil Procedure. At this time, however, it is too early to determine whether judicial economy and efficiency could be served by consolidation in the future. Nevertheless, it is evident that there is no basis to warrant joinder at this time, and the present motion should be denied. Factual and procedural background. As set forth in the plaintiff's complaint, on the evening of January 28, 2022, defendant Karen Reed consumed 9 alcoholic drinks during an approximately 3-hour period at 2 different restaurants prior to getting behind the wheel of her SUV with her boyfriend, Boston Police Officer John O'Keefe III. At that time, defendant Reed was deeply intoxicated and unable to safely drive her vehicle. Nevertheless, after a night of drinking, defendant Reed drove Officer O'Keefe to Mr. and Mrs. Albert's home at 34 Fairview Road in Canton, Massachusetts. After Officer O'Keefe got out of defendant Reed's vehicle in front of the home, defendant Reed hit him with her car while she was intoxicated as she left. Rather than stop, defendant Reed left Officer O'Keefe lying seriously injured on the ground in front of 34 Fairview. And my question to you is, if they saw her pull up and saw her backing up and saw her pulling forward and whatnot, and Matt McCabe saw the tire tracks in the shape of a Y or a K, indicating that she made a 3-point turn, why the hell did nobody see this big 6'2" man laying on the ground in the front yard? Can you answer me that? No, nobody can answer that. So, excuse me, but fuck all off. Fuck all the way off on that one. So, let's go back to see where I left off. Injured on the ground in front of 34 Fairview Road, Officer O'Keefe tragically died from the injuries he suffered when defendant Reed struck him with her car. Except for that, it was proven in trial number 2 that Officer O'Keefe was never hit by an automobile, and Officer O'Keefe never hit Karen Reed's SUV, and Karen Reed's SUV never hit John O'Keefe. So there's that. They are, they're failing to mention that in this opposition. But we will bring it to everybody's attention when it's time. After hitting Officer O'Keefe, Defendant Reed then drove her vehicle to Officer O'Keefe's home. A few hours later, at approximately 4:30 a.m., Defendant Reed was frantic and woke up Officer O'Keefe's then 14-year-old niece and talked about how Officer O'Keefe was not home, that Officer O'Keefe may be dead, and that Defendant Reed may have hit Officer O'Keefe with her car. Defendant Reed arrived at 34 Fairview Road at around 6 a.m. Defendant Reed immediately spotted Officer O'Keefe in the area where her car had struck him a few hours earlier. Defendant Reed was hysterical. At the home, Defendant Reed repeatedly stated that she hit Officer O'Keefe. Defendant Reed never told anyone in January 2022 that she saw Officer O'Keefe enter the home at 34 Fairview Road. And Jennifer McCabe never told anybody that she saw Officer O'Keefe get out of the car. So, hello. According to testimony at trial, shortly thereafter, Defendant Reed spoke to the police. Defendant Reed told the police that she did not see Officer O'Keefe enter the home at 34 Fairview Road. Similar to Defendant Reed, the police questioned each of the Commonwealth witnesses, and each told the police that Officer O'Keefe had never entered the home. A few days later, Defendant Reed was arrested for causing the death of Officer O'Keefe when she hit him with her car as she was drunk driving. Defendant Reed was eventually indicted by a grand jury and charged with second-degree murder and manslaughter in the death of Officer O'Keefe. In the spring of 2023, Defendant Reed, while awaiting trial individually and in conjunction with third-party Aidan Carney, embarked on a strategy to defame the McCabes, the Alberts, and Mr. Higgins by falsely accusing them of inter alia, murdering and or covering up. Murdering and or covering up the murder of Officer O'Keefe. Defendant Reed did so to evade responsibility for causing the death of Officer O'Keefe by diverting attention from herself. As outlined in a police affidavit, Defendant Reed started to coordinate with Mr. Carney in April of 2023, initially using an intermediary to coordinate Mr. Carney's public communications. Defendant Reed and Mr. Carney also relied on the messaging app, Signal, to communicate and coordinate strategy. Defendant Reed's and Mr. Carney's unlawful campaign, individually and collectively, to defame the Commonwealth witnesses has caused them substantial injury. In the spring of 2024, Defendant Reed stood trial at Norfolk Superior Court. Defendant Reed did not testify on her behalf at the trial. Can they bring that up? I thought that can be held against you. That trial ended in a mistrial due to a hung jury. In August 2024, the plaintiffs filed the present wrongful death action against Defendant Reed and other defendants. The court stayed this wrongful death case pending Defendant Reed's retrial. In the spring of 2025, Defendant Reed was retried. She again did not take the stand in her defense. The jury found that the government failed to meet its burden of proof on all counts except the charge of operating a vehicle under the influence. After that verdict, this wrongful death action resumed. In August 2025, Defendant Reed moved to dismiss the complaint. In early October 25, this court denied her motion to dismiss as to all counts except one. Then on October 20th, 2025, Defendant Reed answered the complaint. Just 1 second. I will be right back. Okay, sorry about that. Um, Let me see. Where were we? Um, Resumed. On October 28, 2025, Defendant Reed served this motion pursuant to Rule 21 governing misjoinder of parties and asked this court to allow her to file a 9-count proposed cross-claim with a mix of state and federal causes of action against 10 new parties, including the Commonwealth witnesses. Argument 1. Rule 21 is not the proper vehicle for Defendant Reed to join the Commonwealth witnesses and assert the proposed cross claims. As an initial matter, the present motion is procedurally deficient as Defendant Reed mistakenly brings her motion under Rule 21 of the Massachusetts Rules of Civil Procedure, which is not relevant to her proposal to add new cross-claim defendants and cross-claims related to her criminal prosecution to this wrongful death action. Rule 21 governs misjoinder of parties and states, quote, misjoinder of parties is not a ground for dismissing an action. On motion or on its own, the court may at any time on just terms add or drop a party. The court may also sever any claim against a party, end quote. Under this rule, the court has the discretion to overcome a technical problem of misjoinder by adding the correct party or severing claims against a party. Failure to join indispensable party does not require dismissal under mass law. No abuse of discretion in allowing plaintiff, after hearing on the merits, to amend complaint to add the Commonwealth as an indispensable party defendant. Rule 21 is inapplicable here. Defendant Reed does not seek to cure a deficiency in the current pleadings. Instead, she seeks to add entirely new parties and subject them to entirely new claims surrounding not the circumstances of Officer O'Keefe's death, but rather her own criminal investigation and prosecution. Indeed, Defendant Reed's citation to Kaiser Found Health Plan, in her motion highlights her misuse of Rule 21. The court held that the regional subsidiaries of the Kaiser Foundation Health Plan could be added as plaintiffs pursuant to Rule 21 to the lawsuit after trial to avoid a standing challenge on damages. The court found that there was no prejudice to the defendant, Pfizer, by the Rule 21 joinder because Pfizer had the opportunity to fully litigate the damages associated with the subsidiaries throughout discovery and at trial. In other words, Inbray Neurontin marketing and sales practice concerned a technical correction of the parties, not claims, in a case in which the parties had effectively litigated as if the new parties were always part of the lawsuit. This is not so here. Defendant Reed's proposed new pleading brings in new parties and new claims that are not part of the pending wrongful death action. While the wrongful death action and Defendant Reed's new pleading are broadly related to the tragic death of Officer O'Keefe, the wrongful death action directly addresses what happened to Officer O'Keefe the evening of January 29, 2022, while Defendant Reed's proposed claims and allegations relate to the events that occurred after the death of Officer O'Keefe during her multi-year prosecution. Instead, Defendant Reed should have sought to amend her answer under Rule 15 and sought to join the new parties, including the Commonwealth witnesses, under Mass Rule 20, which governs permissive joinder. Defendant Reed failed to do, and that alone warrants denial of this motion. Roman numeral 2. Joinder will cause delay and prejudice without any efficiency or judicial economy. Even if this court were to treat Defendant Reed's motion as being made under Rule 20, the motion should still be denied. Under Rule 20, I sound like I'm saying rural. Under Rule 20, this court has the discretion to allow joinder of parties and counterclaims, but should only do so where it would, quote, promote trial convenience, end quote, and not where it would result in, quote, prejudice, expense, or delay, end quote. Here, the court should decline to exercise such discretion. Defendant Reed's proposal to join the Commonwealth witnesses and other third parties to this wrongful death action would not advance judicial economy at this stage, but rather would substantially increase the complexity of the pretrial proceedings and result in delay and prejudice to the Commonwealth witnesses and the plaintiffs. There are several reasons for this court not to exercise its discretion to join the Commonwealth witnesses to the existing wrongful death action. Do tell what those reasons are. Defendant Reed's proposed course of action will prejudice the Commonwealth witnesses' discovery and jurisdiction rights and will substantially complicate and delay the pending wrongful death action, and new parties' claims, factual disputes, and legal issues without any genuine judicial efficiency gains. A. The Commonwealth witnesses will have substantial motions to dismiss if Defendant Reed is allowed to file her proposed cross-claims in this action. If Defendant Reed is permitted to file the proposed cross-claims against the Commonwealth witnesses in this wrongful death action, or if she files it in a separate action, those pleadings will be subject to substantial motion practice. Anticipated motions to dismiss include requests for dismissal based on the Massachusetts Strategic Litigation Against Public Participation Act. Wow. The anti-SLAPP statute, as well as on statute of limitation grounds. Such motions are likely to be successful or, at the very least, substantially narrow the scope of Defendant Reed's proposed cross claims. Footnote 1. In Bristol Asphalt Company, the Supreme Judicial Court recently established a two-part test for consideration of an anti-SLAPP motion. If the moving party establishes that the challenge conduct is based solely on the moving party's petitioning activity, then the burden shifts to the non-moving party to established by a preponderance of the evidence that the petitioning activity was, quote, devoid of any reasonable factual support or any arguable basis in law, end quote. Here, Defendant Reed's claims against the Commonwealth witnesses are based unquestionably on core petitioning activities speaking to the police. Defendant Reed cannot show those activities were, quote, devoid of any reasonable factual support, end quote. Indeed, Defendant Reed complains that the Commonwealth witnesses told the police that Officer O'Keefe did not enter the home at 34 Fairview Road, but that is exactly what Defendant Reed told the police in January 2022. She never told the police that he didn't enter the home. Come on. That's bullshit. Okay, I need to get some coffee real fast. My mouth is dry, so give me a minute. I'm sorry, I know I just took a minute break, but I forgot to get coffee, so I will be right back. Okay. Sorry about that. Now I need to double check and make sure because I changed out my earbuds too, so I want to make sure that these ones connected. So just one second. Um, um, sorry. Please connect. Um, come on, come on, come on, come on, come on. Okay, I may just have to do it without him because I'm not going to take all this time too. There we go. Okay, we're good to go. Done. Sorry about that. And let's get back to it, shall we? Okay. Moreover, under the anti-SLAPP statute, all discovery in this proceeding would be automatically stayed once the Commonwealth witnesses file that special motion to dismiss. While the court could resume discovery for some existing claims in the wrongful death action, there is a serious risk of multi-tiered discovery if defendant Reed's proposed cross-claims are brought into this case at this time. These timing issues are compounded because the Commonwealth witnesses would have the right to an immediate appeal if that anti-SLAPP motion were denied. Given the significant legal deficiencies in defendant Reed's proposed cross-claims, this motions practice could take the parties several months, if not longer, to brief and for the court to resolve these motions. Further, if some of defendant Reed's proposed cross-claims were to survive dismissal, they keep saying that, survive dismissal, the Commonwealth witnesses could be compelled to file their defamation action as counterclaims against defendant Reed and Mr. Carney in the present action. That could result in further motion practice. So be it. In the meantime, just quit threatening with the defamation suit and do it already if you think you can. I don't think you can, and that's why haven't done it yet. In the meantime, discovery in the present wrongful death action could be substantially complete. Indeed, the current discovery schedule ends in August 2026, which may leave only a few months for discovery on defendant Reed's cross-claims and the Commonwealth witnesses' defamation counterclaims. That truncated discovery would needlessly and substantially prejudice the Commonwealth witnesses, which alone also warrants denial of this motion and a direction that defendant Reed pursue a separate action. Exercising discretion to deny joinder when it would not provide the new party sufficient time for discovery and relatedly delay the pending proceeding. Alternatively, discovery in the wrongful death action may be stayed pending these motions, which would also needlessly delay adjudication of the lawsuit. Footnote 2. To the extent there are any efficiencies that can be achieved in discovery, that can be accomplished in separate proceedings under Mass R Civil. La-ti-ta-ta, right? B. Defendant Reed's joinder strategy will prejudice the Commonwealth witnesses by likely foreclosing their right to remove the litigation to federal courts. Next, Defendant Reed's proposed cross claims include several counts arising out of federal law, including count 4 for conspiracy to deprive Miss Reed of her Fourth Amendment rights against the McCabe's, the Alberts, and Mr. Higgins. Absurd as it is on the merits, if Defendant Reed files this pleading in a separate action, the defendants would have the statutory right to remove Defendant Reed's complaint to federal court under 28 U.S.C. However, by adding these claims as proposed cross claims in the plaintiff's wrongful death action against the proposed, quote, counterclaim defendants, end quote, Defendant Reed will likely foreclose Commonwealth witnesses' right to seek removal to federal court. In particular, the Supreme Court has held that removal under 28 U.S.C. is not permitted for counterclaim defendants. Counterclaim defendant cannot seek removal to federal court under 28 U.S.C. Since then, courts have expanded the Supreme Court's reasoning to include 28 U.S.C. 144.1, which covers removal for federal question jurisdiction. Given Defendant Reed's tenuous basis to seek leave to join claims relating to her criminal prosecution to this wrongful death action, the court should avoid inflicting undue and unfair prejudice upon the proposed new cross-claim defendants. By denying the motion and forcing Defendant Reed to file this pleading as a new action, the court will ensure that the proposed counterclaim defendants' jurisdictional rights are not inappropriately foreclosed. C. If the motion is allowed, the Commonwealth witnesses will have to file defamation and other related counterclaims against Defendant Reed and third party Aidan Carney in this wrongful death action. See, they keep threatening that. If you go through with this, we're going to counterclaim with defamation. Go for it. Do it. Shit or get off the pot, you pieces of shit. I mean, Jesus Christ. File it already. I mean, Aidan Carney's done everything but take you by the hand to go do it, because he knows you cannot. There's no grounds. Finally, Defendant Reed's motion would not only expand the present wrongful death action with her proposed cross claims and the additional parties related to her criminal prosecution, but the Commonwealth witnesses would also be forced to file counterclaims against Defendant Reed for defamation and other torts in this action. The Commonwealth witnesses also would have to join third party Mr. Carney to this action to assert similar counterclaims for defamation and related torts. As explained above, Defendant Reed and Mr. Carney, both in concert and separately, have defamed and substantially injured the Commonwealth witnesses through myriad false statements about them, for which the Commonwealth witnesses have planned to seek justice in a separate action. They weren't false claims. I mean, look at Proctor. They were saying that, we were defaming him, and look at him. What a piece of shit he turned out to be. I mean, we all knew it, but we had to prove it. While the Commonwealth witnesses and every single one of those witnesses was caught in at least one lie on the stand. Every single one of them. So they are not being defamed. They are pieces of shit. While the Commonwealth witnesses contend their defamation claims and other torts against Defendant Reed and Mr. Carney should proceed in a separate lawsuit, if Defendant Reed is permitted to bring her proposed claims in this action, the Commonwealth witnesses may be compelled similarly to bring their defamation claims in this lawsuit as well. These additional claims and parties related to unlawful conduct by Defendant Reed and Mr. Carney after the death of Officer O'Keefe would further complicate this wrongful death action by increasing the number of parties, claims, factual disputes, and legal questions. As a result, Defendant Reed's motion would not create any judicial efficiencies at this stage by having these disparate legal claims based on different facts and time periods against different parties in a single lawsuit. Roman numeral 3. Rule 42, consolidation may be appropriate between the separate lawsuits at a later time. Defendant Reed provides no genuine justification for adding the proposed cross-claims and the 10 new cross-claim defendants to the pending wrongful death action. As stated earlier, Defendant Reed's proposal will substantially expand the scope of the pending lawsuit, including dramatically increasing the number of claims, parties, issues of factual dispute, and legal questions for resolution. It also risks unduly prejudicing the Commonwealth witnesses by truncating discovery on their claims and artificially foreclosing jurisdictional issues. However, it is possible that if Defendant Reed pursues her proposed cross-claims in a separate action, as she should be required to do, the parties in the court may determine after motion practice is complete that there may be some efficiencies from consolidating discovery or the claims for trial under Mass R. Civil P 42. Until motion practice is complete, the parties will not know the potential for judicial economy from consolidation. At that time, the parties and the court will be able to assess the remaining claims and parties, including the defamation claims against Defendant Reed and Mr. Carney, and be better situated to determine whether consolidation is warranted. Conclusion. For the foregoing reasons, Commonwealth witnesses respectfully request that the court deny, all in caps, Defendant Reed's motion pursuant to Rule 21 to file the proposed cross-claims in the pending wrongful death action. Respectfully submitted, Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins by their attorney. Now see, this one says attorney singular. The last one said attorneys plural. Certificate of service. Wow. Just wow. I don't know. I don't know. I don't know. I want to see if I can find what Michael Proctor is being compelled to turn over. And now all of a sudden I'm not able to frickin'. Okay, let's try this again. This whole, oh my God. Okay, so read. Okay. Now, let me see if I can find the part about not finding that about the Michael Proctor crap. now. Okay, so let's go back and try the Plymouth Court. Okay, so 11, 24, 24, 24, 11. Holy crap, there's a lot of stuff filed in this one. Motion to compel. Okay, I think this is it. Let's see. Nope, that's the motion to compel him to turn over the documents, but I want to know what documents she wants from him. Motion to compel Brian attorney, the date, attorney appearance. I'm not seeing it. Court rule. Let's see if this is. That might be all we have. Which wouldn't be so bad, right? Oh, wait, here we go. Okay, so you guys can't get rid of me so soon. Sorry. Says it's a 28-pager, but we'll see, because the other one said that they were 66 pages, and they weren't, so there were just a lot of double copies of shit. So, okay. And here we go. Memorandum of law in support of motion to compel Michael Proctor to produce documents pursuant to subpoenas. Defendant Karen Reed respectfully requests that the court compel former Massachusetts State Police Trooper Michael Proctor to produce documents due as long as 3 months ago. Reed served a subpoena on Proctor in hand in July of 2025. Reed also served a second subpoena seeking a discrete set of additional documents in October 2025. Proctor acknowledged receiving both subpoenas and requested repeated extensions to respond. However, to date, Proctor has failed to meet all new agreed to deadlines and has not substantively responded to either subpoena or produced any documents. The court should compel him to do so. Facts. Plaintiffs allege that Reed backed her car into John O'Keefe III on January 29, 2022, and caused his death. They also allege that Reed created a false narrative, quote unquote, that someone else killed Mr. O'Keefe and that the police investigation into his death was corrupt, biased, and designed to deflect attention away from the law enforcement officers and their families who were inside the house at 34 Fairview Road in Canton the night Mr. O'Keefe died. Plaintiffs claim Reed's assertion of this alleged quote-unquote false narrative supports their, quote, negligent, reckless infliction of emotional distress, end quote, claims against Reed. In an effort to defend against plaintiff's claims by, in part, proving that this narrative is actually true, on July 23, 2025, Reed served the first subpoena on Proctor by hand. Proctor led the investigation into Mr. O'Keefe's death, which led to Reed's arrest and prosecution. He is central to the quote-unquote narrative on which plaintiffs rely. The first subpoena requires Proctor to appear for deposition and seeks various categories of documents, including all documents and communications concerning Reed, Mr. O'Keefe, and the investigation into Mr. O'Keefe's death. Woo! Other potential witnesses and suspects, and other relevant topics. Footnote 1. The first subpoena required Proctor to produce those documents by August 5th, 2025. Footnote 1. A true and accurate copy of the first subpoena, including the return of service, is attached as Exhibit 1. On July 28th, attorney Daniel Moynihan, Proctor's counsel, in his administrative appeal of his termination from the Massachusetts State Police, contacted Reed's counsel, stated that he was, quote-unquote, confirming that his office would represent Proctor in connection with this case, and asked Reed's counsel to continue the deposition and wait a week before settling on a new date for the production of documents. Reed's counsel agreed, but attorney Moynihan did not follow up and did not respond to further emails from Reed's counsel on August 27th or September 11th. Well, yeah, because they cut him off. They said, see ya. They know what a piece of shit he is. On September 15th, Reed's counsel sent a letter to attorney Moynihan's office demanding a response. The next day, another attorney from attorney Moynihan's office, Mark Russell, that's much easier to say, responded to Reed's counsel. Attorney Russell indicated that his firm had not been retained to represent Proctor in connection with this case and did not propose any new deadline for Proctor's response to the subpoena. Reed's counsel followed up multiple times to clarify attorney Moynihan's and Russell's firm was authorized to speak on Proctor's behalf in connection with the subpoena. Yeah, if they're not representing him, they can't respond on his behalf, right? Ultimately, attorney Moynihan stated the firm was not and claimed that he was only trying to facilitate a response. Well, thank you, but no thank you. Stay in your lane, kind sir. Reed's counsel explained that he needed to confer with counsel who actually represents Proctor in connection with the first subpoena to see if the parties could agree to a new production deadline and avoid motion practice. No new counsel appeared, and Proctor did not produce any documents or written response to the first subpoena because they don't have to where they come from. You never turned over the search warrants in the Miles King case, right? So why should he have to do that in any case? He's never been held accountable, apparently. On October 22nd, 2025, Reed served Proctor with the second subpoena. Footnote 2. A true and accurate copy of the second subpoena, including the return of service, is attached, which relates only to documents concerning certain quote-unquote disclosures made to attorney Moynihan the previous week by the Norfolk District Attorney's Office, and Proctor's decision to abruptly withdraw his administrative appeal as a result of these revelations. The second subpoena was left at Proctor's last and usual address, which I don't think he's living at anymore. After receiving the second subpoena, Proctor called Reed's counsel directly on October 24th and left a message. They spoke on October 27th. During that call, Proctor confirmed that he was not presently represented by counsel and explained that he needed more time to produce documents because he was in the process of finding counsel and a place to live. Sorry. Reed's counsel explained that it had been months since Proctor had received the subpoena and that Reed would move to compel production if Proctor did not agree to an acceptable date by which he would produce documents. Proctor asked Reed's counsel not to serve such a motion that week to allow Proctor to engage counsel. Reed's counsel agreed. I wouldn't. I'd say, you know what? Fuck you. Why should I give you anything? Why should I allow you to have any time? You don't deserve it after the shit you said about her. Reed's counsel agreed, and Proctor said his new counsel would reach out by October 31st. No new counsel appeared for Proctor by that date. Imagine that. Indeed, as of the date of this motion, no counsel has appeared for Proctor. He doesn't have any money to pay for one. Instead, Proctor called Reed's counsel again on October 31st and said that Reed's motion to add parties, which had been served in the interim, had caused the attorney he planned to hire to refuse the engagement. Bullshit. Proctor asked for even more time. Nope. Reed's counsel explained that he could not agree to further delays where the documents in question had been due 3 months earlier. Proctor has not objected to either of the subpoenas. Analysis. The court should compel Proctor to produce all documents and information in his possession, custody, or control that are responsive to the subpoenas. The subpoenas seek potential evidence that would be highly relevant to the truth of the alleged quote-unquote false narrative. Plaintiffs rely on their emotional distress claims. Proctor led the investigation into Mr. O'Keefe's death for the Massachusetts State Police and was a primary focus of the allegations and statements Reed made, which plaintiffs claim caused them harm. Specifically, Reed has alleged that Proctor deliberately ignored, manipulated, and falsified evidence and planted to direct the investigation away from other potential suspects and towards Reed. It is vital to her defense that she is permitted to, among other things, prove that such allegations were true when she made them, and Proctor's documents are directly relevant to that point. Therefore, they are well within the scope of discovery. Do you think he still has them? Although Reed cooperated with many of Proctor's requests for extensions to avoid the need for motion practice, it has been 3 months since the vast majority of the documents were due, and Proctor is not committed to any deadline for production and is not, to Reed's knowledge, currently represented by counsel with whom Reed's counsel can confer. Therefore, the court should order Proctor to comply with his obligations and produce the documents. Conclusion. For the foregoing reasons, Reed respectfully requests that court allow the motion and compel Proctor to produce all documents and information responsive to the subpoenas within 10 days of the court's order. Respectfully submitted, Karen Reed, by her attorneys. Certificate of Service. Exhibit 1. Subpoena. Greetings to Michael Proctor. Oh, I should have retracted that, his address. Greetings, you are hereby commanded in the name of the Commonwealth of Massachusetts, pursuant to the provisions of Rule 45 of the Massachusetts Rules of Civil Procedure, to produce the documents identified in the attached Schedule A at the office of Sheehan, Finney, Bass, and Green, Pennsylvania, 28 state. Okay, so you are further commanded to appear at the offices of Sheehan, Finney, and whoever on August 28, 2025, well, that's come and gone, at 10 a.m., and to testify as to your knowledge at the taking of a deposition in the above entitled action before a notary public in and for the Commonwealth of Massachusetts, or before some other officer authorized by law to administer oaths. The deposition will continue day to day as necessary and will be recorded stenographically and by audio-visual means. Here of fail not, as failure by any person without adequate excuse to obey the subpoena served upon him may be deemed in a contempt of court in which the action is pending. Certificate of Service. Schedule A definitions, unless specifically indicated or otherwise required by the context in which the terms, names, and instructions are used. Okay, that's just like a little vocabulary list. Instructions. If any document is withheld under a claim of privilege or other protection so as to aid the court and the parties hereto To determine the validity of the claim of privilege or other protection, please provide the following information with respect to any such documents. Okay, this is all documents, video or audio recordings, and communications, including but not limited to emails, text messages, and other forms of instant messages to, from, or concerning Karen Reed or any of her family members, heirs, assigns, employees, contractors, agents, attorneys, or other representatives. Woo! So she wants everything. All documents, video, or audio recordings, and communications, including but not limited to emails concerning or referring to the death of John O'Keefe, concerning her black Lexus, or concerning John O'Keefe II, Paul O'Keefe, or Margaret O'Keefe. All documents, video, or audio recordings and communications, including but not limited to emails, text messages, and other forms of instant messages to from or concerning Brian Albert, Nicole Albert, Chris Albert, Julie Albert, Colin Albert, Brian Higgins, Jennifer McCabe, Matthew McCabe, Allison McCabe, Carrie Roberts, or any other individual present at 34 Fairview Road, Canton, Massachusetts, on January 28th or January 29th, or any interviews, meetings, conversations, or encounters with any such individuals from January 1, 2021 to the present. Provide for forensic examination and copying all cellular or smartphones, computers, tablets, smartwatches, GPS devices, motor vehicle navigation systems, or other electronic devices that record their location or can facilitate communication of any kind, which you used either personally or professionally at any time from January 1 through the present. Holy shit. All documents, so they thought that they got a lot from his phone download. They're going to get a shit ton from this. All documents, video or audio recordings and communications, including but not limited to emails, text messages, and other forms of instant messages to, from, or concerning any member of the Canton Police Department from January 28th to present. Let's start at the beginning of this because I didn't realize this was the list. Document requests. All documents, video or audio recordings and communications, including but not limited to emails, text messages, and other forms of instant messages to, from, or concerning Karen Reed or any of her family members, heirs, assigns, okay, we read that one. Number 2, all documents, video or audio recordings and communications, including but not limited to emails, text messages, and other forms of instant messages concerning the black Lexus. Okay, we said that one. Okay, we said that one. Oh, so I was right on. Okay. Sorry. All documents, video or audio recordings and communications, including but not limited to emails, text messages, and other forms of instant messages to, from, or concerning any member of the Canton Police Department from January 28th through the present. All documents, video or audio recordings and communications, including but not limited to emails, text messages, and other forms of instant messages to, from, or concerning any member of the Boston Police Department from January 28th through present. All documents, video or audio recordings and communications, including but not limited to emails, text messages, and other forms of instant messages concerning 34 Fairview Road. All documents, video or audio recordings and communications, including but not limited to emails, text messages, and other forms of instant messages concerning any dog owned, kept, or fostered by any member of the Albert family at 34 Fairview Road, Canton, from January 1st, 2021 to the present. All documents, video or audio recordings and communications, including but not limited to emails, text messages, and other forms of instant messages concerning any investigation by any federal agency, department, board, administration, office, or agent relating in any way to the death of John O'Keefe III from January 28th, 2022 to present. Just one second. Number 12, any documents, video or audio recordings or communications, including but not limited to emails, text messages, and other forms of instant messages concerning any gifts or items received from any member of the Albert, McCabe, Roberts, or Higgins families from January 28, 2022 to the present, including but not limited to copies, photographs, or other representations of any such gifts. It should say any gifts given to you or your wife, because didn't he say give it to Elizabeth? All documents, video or audio recordings, and communications, including but not limited to text messages and other forms of instant messages to, from, or concerning Yuri Buchanan from January 28, 2022 to present. All documents, video or audio recordings, and communications concerning any disciplinary investigation, proceeding, decision, action, or appeal concerning your conduct as a trooper or other rank within the Massachusetts State Police from January 1, 2021 through the present. All records of any iCloud or other backup data that includes any documents, communications, messages, or other data, including metadata that were sent, received, created, edited, stored, copied, altered, or accessed between January 28, 2022 and present. He's screwed. He is screwed. Affidavit of service. I, Brent A. Bellamy, on oath, depose, and state as follows. I am a private investigator at so-and-so, a full-service private investigator. Dependent is not a party here. And okay, so what is this? To obtain services upon Michael. Oh, this is just his certifying that he served the subpoena to Michael Proctor. Exhibit 2. This is the greetings, the subpoena. And this is the vocabulary list again in the instructions. For all documents currently stored in electronic format, produce those documents in their electronic native form with all metadata intact. For example, emails should be produced in PST format, and audio and video recordings should be produced in their native forms with all metadata intact. If you intend to produce documents in a format other than that specified in these instructions, please notify plaintiff's counsel before making the production. To the extent you obtain possession, custody, or control of a document that is responsive to these requests, after you make your production in response to these requests, you must supplement that initial production with the newly acquired document. Woo! That is all she wrote. Wow. So, I don't know. To me, it sounds like she's going for the throat of Proctor for sure, but pretty much for everybody, I think. And she deserves to. She deserves to. I just hope that everything works out for her. We are here for her. You know, we all support her for her civil cases. That hasn't changed. So, I don't know what else to say other than I hope everybody has a wonderful Thanksgiving. Be safe. Enjoy your families. Enjoy your food. Nothing like good food and family to make your heart feel warm and happy. I will be thinking of you all, and maybe I will see you Friday morning. I don't know. I work all weekend, so I work Thursday, Friday, Saturday, and Sunday night. It's kind of hard to do streams after work when I should be going to bed, but we'll see. I never do what I say I'm going to do, so anyway, I wish you all the very best and happy holidays. And don't forget to like and subscribe, and thank you for joining me. I really appreciate it. Bye bye.